Hello, hello, everyone, and welcome back to another episode of Speaking Legally, where the legal meets the cultural. Thank you so much for tuning in. You know, we're with you every Wednesday, 4 p.m. Eastern Standard Time. And we thank you for always being here, sharing your thoughts, being a part of the dialogue, and sharing this broadcast with your friends. So, as we always do, we want to take a moment to have our legal experts say hello to you before we dive into today's show. I can't believe the month of October is slipping away, the best month of the year, says me. But let me turn it over to Senor Pichardo. How are you doing, Ed?
Hello, buenas tardes. Good afternoon, everyone. Welcome to the show today. As usual, I feel you're going to find the information to be informative and quite fulfilling. We got a lot to cover here today, so thank you for joining us.
Awesome. And Mr. Russell, over to you.
Hey, thank you for having us in your home again and on your phone, on your tablet, on your computer. And like Ed said, we know that our information will guide you in the right place at the right time, should you need it. So let's start with the show.
Awesome. So, as everyone should know, it is time for us in the city of New York to exercise our right to do what? Vote. Early voting is happening, and we hope that you are taking full advantage of the early voting period. And we have the dates here published for you, going all the way from the 23rd until Sunday, the 31st. So you have an opportunity to go in ahead of the lines, ahead of um, any inclement weather. You can go ahead and exercise the right to vote early. This is new in New York, so we really need people to take advantage of it so we don't lose this option. Any words from my legal experts on early voting?
Now, I think early voting is a definite promotion of democracy here. It was sad before this that citizens of the state of New York and in other places, because I believe they got early voting in Jersey as well. You were relegated to that one day to make a decision, and there have been cases in the past. I think even for me where that election day just didn't work, and it was a busy day. I couldn't go vote early before work, and then I had to work late and just didn't get around to it. Very rare, but it has happened. So I'm really happy, and I agree with Dr. Grant. Folks need to take advantage of this, because at some point, if people don't take advantage of it, someone is going to start arguing for it to be abolished based on the cost, because it does cost money. You got to pay the staff to be there, the poll workers, you got the poll watchers there, etc. So it's definitely a great thing. I believe it's going to go on till Sunday, and then you got election day on November 2nd. What I also want to impart to people also is for those who don't know, is that yes, you voted on primary day. A few months ago, you voted. You cast your vote. Now is the general election. So you got to vote twice. The previous vote was the party primary. If you were a registered Democrat, you voted for the Democratic choices on the ballot. If you were Republican, the Republican choices. But now is the general election. So, like for instance, for mayor here, you got the Democratic nominee Eric Adams, running against the Republican nominee Curtis Lewa, and that on down with some of the other. And this is a big election, by the way, because I believe you have all of the New York City Council seats, up for election here. And we're talking about those who are like running to get the seat for the first time, because New York City Council is term limited, and then you got another set of city council persons that are incumbents but also trying to keep their seats. So it's this is a big one, and all of the city offices are up for grabs too. You got the public advocate, mayor, comptroller. So it's very, very, very important for folks to come out and cast their vote.
It's almost like Christmas shopping, in that Christmas is a date away and you don't want to wait until the last day to do your shopping.
Mm-hmm.
And early voting is like Black Friday. So just think of it from that perspective. It allows you to get out early to handle your business. plan your work and work your plan. And I'm always a believer of that. This is not ranked choice voting. So this is voting ABC, the good old days voting, where you just go in and you just press one button. And so there's no confusion as to is who is running for what. And there's multiple days for you to do that. And you should take hold of those multiple days. Now, you can't go in on Monday and vote for mayor and say, oh my God, I forgot city council and go in on Tuesday. It doesn't work that way. When you go in, you have to make your choices for all. And as we air this show, you should take the time to find out who's running for city council, who's running for those seats that Ed spoke about for the first time, who's the incumbent, who's the challengers, who is running for what, when, and where. Whether you live in New York, live in New Jersey, or any other state. It is a pivotal time, I would agree. The face of New York might have a little color to it. That's the prediction. And hopefully, although as much as I love our ancestor, David Dinkins, hopefully we have a transition of power and opportunity for those who are out there trying to move the African, Latino African experience along the social economic plights that we've been fighting against for a long time. And so here's our opportunity.
I also would like to mention that there are several ballot proposition measures also, meaning that there are certain legal changes that have to be voted for by referendum. So I would ask folks to do their research on those issues before casting a vote. A number of them, I believe, have to do with certain voting changes, absentee ballots, voter registration. I forgot what the other two, I believe it's 4 of them. So, you definitely want to take a close look at those before you go into the booth, read them carefully before you decide. It didn't move past me that my colleague made a slight dig at ranked choice voting, which was a ballot proposal some time back that the majority of voters voted in favor of.
I just wonder what that majority looked like. Was that majority of 1, or majority of 2, or majority
including
of 3?
Myself?
Because nobody knew about it and nobody was focusing on it. Let that be a lesson to our listeners and our viewers. Don't let anything slip by. Next thing you know, you be ranking and choicing and voting.
It wasn't no slipping and sliding. Folks wanted more than one choice.
No, people did not pay attention, and it came on
and
the
then
ballot.
things happen.
I'm showing now what's on the ballot so that we learn from the ranked choice experience. No matter how you feel about it, now you can learn from it. And here are the 4 proposals that are here: the redistricting process, the right to clean air, clean water, and a healthy environment, same-day voter registration.
Let's stop right there. The same voter registration. That's a biggie. I mean, you haven't registered, you have a conversation, and you want to do it that day. Why not? If you can validate that's big. No excuse for absentee voting. That's big. Those are big things.
Yeah, and I hope people read it because
if you look at the jurisdiction of the New York City Civil Court, is being
that's major.
The threshold is being raised from 25 to 50K.
Right, so, that's major.
Yeah.
So that means any lawsuit for our listeners, any lawsuit that is not that doesn't meet that criteria, you got to go into small claims court. You know what I mean? So that's important. That's important. But I say all this to say that for every advancement in the law, there is opportunities on the economic side. And as you said, Ed, polling sites are now available, right? So that means people have to work them. And so maybe there's an opportunity for young folks, elderly folks, anybody that's looking to venture into the area of politics or try to, make some money, start to participate. Start
And
because
listen,
now the sites, now it's not one day, it's multiple days.
and listen, I love early voting. I mean, I remember my first time early voting. It was like a Saturday. I got up. It was like noon. I stretched. I said, let me go get me some lunch, and then I'm gonna go walk over there and vote. It was just good to do it on a weekend versus a hectic Tuesday where you got to get there early before you go to work, or you just stressing because you hoping to get off work early enough to get to the poll site. So now I mean, you got other days, but for those who have hectic weekdays, you got the weekend. And I'm
Is
not
there
talking about
any,
the singer, by the way.
hey, Ed, is there any, and Dr. Grant, is there any judicial elections going on? No, that was taken
Yes,
care of in the primary?
No,
If
no, I
yeah,
we
believe I believe
we
there's,
have.
because I think for some of those
Mhm.
seats there's a Republican and a
all right.
Democratic
So I mean, we
Yes.
need to,
candidate. So you got
you
to
know,
pay attention to those too.
we always talk about here, legally speaking, know the judge, know who's in the courtroom, know what's going on. This is another time. This is another opportunity. I'm not so much into labels, Republican, Democrat. I'm into what's your philosophy, right? I mean, I don't want people to law attorney or civil rights attorney. I'm an attorney. Some areas I specialize and I'm an expert in. Some areas I need to refer you. So I don't want folks to get hung up on Republican or Democrat, but go, especially when it comes down to judges, understand what their background is, understand, who they are, because they may be making critical day-to-day decisions for a loved one, right? That trickle down effect is really trickle down. It can touch one. And so, this is not a district attorney's race right now, in reference to some boroughs, but we know it is as far as Manhattan is concerned, right? And so, be aware. Just be aware. Be aware.
No, you got DA in Brooklyn and Manhattan. So like I said earlier, please, please, please don't feel like it's a wrap. Most of the folks enrolled in New York City are overwhelmingly Democrat. Don't take that chance. Go in there, and if you're a Democrat, and particularly if the Democrat who became the nominee is someone that you actually voted for, you should really try to make sure that you cast that vote in the general election. We don't want to take any chances here.
And the last thing I spoke about was, the DA's office and elections. And I think part of what we're discussing today is some of the functionality of the prosecution and the
That's
DA
right.
and the judge, right? And so,
Absolutely.
what better time than now to really talk about what Dr. Grant is probably going to put up on the screen, because we always like to have a little article next to us,
Indeed.
although we're the
Yes.
focus of this show. There's nothing like a little article on the side just to like let the folks know that
Okay.
we are relevant in the paper.
You are
However,
on a roll today, Mr. Russell. I've
you
never
know what I
heard
mean?
someone talk about voting with Christmas and
As
Black
long as I'm
Friday.
not
So that's
rolling
a good one.
downhill, as long as I'm
Yeah,
not
you're not
rolling
rolling
downhill,
downhill.
we
You
good.
are on a roll. But I early voted. I'm so grateful I could early vote because I have a conflict on election day. So make sure you go out and early vote. Use it. We don't want to lose it. But yes, it just really segues nicely into the whole conversation about plea bargaining and really just understanding what that is. Sometimes you have friends, family, neighbors, community members that get into a situation and they don't know what to do if they don't have an attorney like our legal experts and they're offered a plea bargain. Let's really get into that today. So over to you, Mr. Russell.
Well, first let's start with terminology. Plea bargaining, plea bargain is analogous to a settlement in a civil case. Now, why
Exactly.
do I say that? Let's talk about the civil and then we'll move to the criminal and you'll understand.
And we'll move, and we're going to talk a little bit about kind of the difference between the adult criminal and family court.
Right. So on a broad spectrum, in a civil case, you always have the right to go to trial, or you may come to a settlement. That's where the parties agree that the case should be resolved in a certain way, right? And usually there is a negotiation period before you get to the settlement. Somebody may say this case is worth 10,000. Somebody may say it's 15. You hobble, you negotiate, you come up with 12.5. But once you settle in on what it is, there's no other circumstance, or obstacle that changes that number, unless there's new evidence of some sort that nobody knew about. But there's no procedure that says, you know what, now we're going to take that off the table. So what we say, let's put a pin in it, right, Dr. Grant? Let's put a pin in that thought. Hold that right there. Then you have the criminal, and we describe this as plea bargaining. And the prosecutor and the defense counsel are involved in this, and sometimes the judge. The judge sometimes weighs in on what should happen and should weigh in. We'll put a pin on the judge and talk about the judge a little bit later. But here, the prosecutor, in a vacuum, will decide what is the value of the case. And what do we mean by value in the criminal aspect? What should be the punishment? That's what I mean by value in a criminal aspect. What should be the punishment? And then the prosecutor conveys that, because they, in a vacuum, with the DA, with their supervisors, maybe with the victim, comes up with this evaluation, or this punitive drawing a line in the sand type of decision. And they present that to the defense counsel. And the defense counsel may bring up factors, mitigating factors, evidentiary factors, circumstances that may have the prosecutor rethink what they're thinking about. They should be thinking about those things anyway, but let's just say they didn't have those tools in their wicket basket, so therefore they may have to rethink it. Then they come back with an offer. And that is analogous to the value, once again, on a civil case. So let's just keep it real simple. The offer in this example would be a misdemeanor, and the person does 60 days in jail. Let's just leave it at that. Try not to make it too complicated. But in this particular case, there may be an issue that arises. And the issue is whether or not the officer had probable cause to stop the individual, which is a constitutional right to make sure that the officer has followed the Constitution, or the person that is accused made a statement and wasn't properly advised of their rights. And that statement really kind of is the dot the I, cross the T for the prosecutor to hold on to say, this is why we're saying a misdemeanor in 60 days, or this is why we're moving forward. Or there may be some identification issue. The witness may not have accurately point out the person, or you want to test and see if they pointed out that person correctly. I'm not going to go through the names. We'll save those names of those hearings for another date and another show. But let's just look at those three constitutional rights that you have. A right to ensure that the person got the right person, the accused, right? The accused made a statement, and the constitutionality of the stop in and of itself. What I have found, and that's why we're doing this show, is over the years, and Ed knows this because he's experienced it as a public defender. I've experienced as a prosecutor and a public defender, that district attorney's offices, even though we're under the unified court system, are not so unified in how they go about plea bargaining. And so what do I mean by that? In our example, in 60 days, you may find yourself being faced with, all right, Mr. Little Russell, let's just say, you can go to trial, and if you're convicted, you would have to do 1 year in jail, because that's the maximum in a misdemeanor case. Or you could take this plea for in 60 days. That means you go do 60 days and it's over. That's less than a year, your option. And what defense counsels are faced with is, one, conveying that to their client and having their client make a decision on the heels of defense counsel thinking, looking, reviewing the case, and realize that there may be some constitutional violations somewhere.
Now, can I interject there?
Sure.
Now, this is the basic problem here, right? Just like my colleague Roy said, conveying this to the client. Because once you tell the client, hey, listen, we got these constitutional issues here, they're offering this plea. Now, the client is always going to ask, well, what if we just go ahead and do the hearing? Is the offer still going to be available if we lose? And then that's when it's a problem, right? Because in some
that's when it could be a
it
problem.
could be a problem because
It
some
could be a problem.
prosecutors' offices will say, "Listen, the plea offer is still going to be there," and then some will say, "No, if you don't accept this plea offer now."
Right there, Ed. That's the problem that we are presenting to you, the audience.
So then your client then turns around and says, "Well, can you guarantee me we're going to win that hearing?"
And that is the problem that defense counsels are faced with. So let me say it one more time. When a DA's office does not stay flat, and what I mean by flat, the value of $1 today is the same value tomorrow. Not 20 years, but tomorrow. The value of the dollar today is the same value in America. If you buy a pack of cookies for $1 today, unless inflation happens, you can buy 2 packs of cookies with $1 tomorrow. And what happens is that some DA's office will say that is in 60 days to resolve this case, which your client might be interested in. You as a lawyer have the right to represent your client zealously. You know that there may be something wrong with the arrest. And what the DA does is put the defense counsel in a place where he might actually, or she might actually be committing malpractice, even with the client knowing. What do we mean by that? Well, we're going to forego the hearings. We don't want to do the hearings because you get the in 60 days today, and that's what you're interested in. And the district attorney is saying that if you don't take it and you go to a hearing, not if you don't take it, but if you don't take it and go to a hearing, not if you don't take it and go to trial, you might get punished more. But if you go and do a hearing, if you exercise your constitutional right, if you be the zealous defense counsel that you are, dot your I's and cross your T like Ed Pichardo would, and you want to investigate whether there was probable cause, whether the statement was given with his Miranda warnings or without his Miranda warnings, whether or not the ID was a solid ID. If you test that, then you'll be punished because now the in 60 days is over. That is not flexible justice. That is a fixed justice that punish you and any defense counsel for exercising your right.
Because you're basically being punished for exercising your constitutional right. Your right to at least have that examined, have that police officer's conduct examined. And in fact, I would go as far as to say that some officers will commit unconstitutional actions, understanding that you're going to have this, what do we refer to as a Hobson's choice here, in terms of taking that plea or challenging that stop or that search or that seizure. We're not even or even going to the grand jury and testing the evidence even before testing it, say, at trial.
And if you have a criminal history in the past, then you know that weighs even heavily on you even more because the penalty might be more. Right? And so what we're saying is that, or at least what I'm saying, and you can join in if you want to, Ed, what I'm saying is that we need to do away with that. If I'm a prosecutor and I believe the case is in 60 days, that is what I'm offering as a way of resolution, and you want to test the constitutionality of the stop. Now, I'm being very polite, and you know I am, Ed, because what I'm really am saying behind testing the Constitution is that if the prosecutor has to do his job, if the prosecutor got to call an officer in to testify as to whether the stop was valid, whether it was probable cause, whether or not he read his Miranda warning, whether or not the ID was a valid identification, what the prosecutor is saying is that if you make me do that, if you make me bring it in and question the police officer and you lose, we're going to punish you more. And that is not the job of a prosecutor.
Exactly.
The prosecutor is to do justice.
And in fact, the late great Brooklyn District Attorney Ken Thompson, who recently had 350 J Street, the street right in front of it, named Kenneth P. Thompson Way, Congratulations on that. I attended,
That's right.
me
That's
and my
right.
colleague attended that
Absolutely.
ceremony.
Right.
Yeah.
He talked about this in the documentary 13 by Ava DuVernay. He talked about how the criminal justice system is unfortunately driven by a system of plea bargain where upwards of 85 to 90% of the individuals involved, their cases never go to trial or even a hearing. Very major issues never get litigated or tested because defendants, the individuals charged, are under this like threat of, if you test the system and you lose, we're going to make you pay.
And
We're going
we're
to
not talking
punish you.
about trial. We're not
We're not
talking
even
about
talking
trial.
about trial.
We're talking about
Here, we're
steps
not even
before
talking
that.
about trial.
Right.
In his case, he was kind of talking about trial, but he was also kind of even talking about things like grand jury, suppression hearings, things like that, which, any sort of, like you said, any sort of scenario where you're making that prosecutor work or even that judge deliberate, you are facing some level of punishment if you're not successful, which is absolutely unfortunate.
And so now,
So before you continue, Mr. Russell, let's just circle back for everybody. Because this is happening, what can we do?
all right. So before we get to that point, let me get to the other point. One should be, we talked about early voting and we talked about voting for judges. And you need to know who the players are.
And voting for DAs.
And voting for DAs. So one is a philosophical and an ideology that you need to have in mind when you decide what DA you want to take office. Does that DA have this mindset that you get punished for exercising your rights? Is justice flexible or is it fixed? So that's one. Then you need to look at the judges. What does it mean for a judge? Because a judge has a role in this. A judge can put on the record that I think it is my opinion that what you're doing is wrong. The criminal justice system is not meant to be used that way. And if this man or woman wants to exercise their constitutional right by having a hearing, and you believe the value of the case or the punishment of the case is 60 days, then it should stay that. Because if we find out that the police officer violated his rights or her rights in one shape, form, or another, I, the judge, have served the greater good, because I, the judge, is the checks and balances. See, prosecutors don't believe that they're the checks and balances. They think that they are to prosecute. No, you're not just to prosecute. You are there to check and balance, to make sure the officer has done the right thing, to make sure that justice and punishment is balanced, to make sure that you have the right person. And if you're so involved and engaged in the prosecution and not engaged in the checks and balances, then you become a person that says, well, if I have to call the officers here and they get on the stand, then the A in 60 days is gone. And if the district attorney's office has that mindset, then you have a problem.
And I'm going to tell you something. The other side on this thing is, and you're going to hear this, people clapping and saying, oh yeah, this plea bargain system is great, because what happens is that, we really don't have the resources to do all of these trials or do all of these hearings, or, it's not built for that. So of course we have to create some incentives, right? Or they coded in language about defendants not willing to take responsibility for their actions, and that's why we're punishing you for not extending that offer post hearing or after you've tested the constitutionality of what occurred to you, and what I say to that is that is a perverse incentive, if you will.
Not only is it perverse, who decided that this is the way you should walk? Right?
Because it hasn't always been that way. Anybody who examines the history of the plea bargain will find that this wasn't something that has been in existence for the history of criminal law, the law. This is something that eventually came into being and really reached where it's at now because of the level of over criminalization and over incarceration. That's really and over policing. This is what we have because of that. And if you feel like there aren't enough resources, then maybe you need to dedicate more resources to it. I rather we dedicate more resources than to treat individuals unfairly or unconstitutionally.
And I want our audience to hear
Absolutely.
I want our audience to hear us loud and clear. I'm not saying that a defendant who tests their constitutional right is innocent. I'm not saying that. I'm just saying that you have the right to do that. That's in the Constitution. So why should I be punished more for testing that right? You should be allowed to test that right. And I think, Dr. Grant, you had said, well, how do we attack that? What do we do? So we talked about voting. We talked about voting, district attorney. We talked about, in reference to the prosecutors in and of itself. But the other part for defense counsels who are out here, they need to take it upon themselves to put forward the fight and say and call it what it is. Judge, you know what? I'm in this situation where my client wants to evaluate the constitutionality of his arrest. And what I'm being told is that the offer is A in 60 days. However, if I test the constitutionality of his arrest, then that plea is now gone and it turns into A in 90 days or A in 120 days. That's not justice. That is being punitive merely because the DA's office has to come forward with proving the constitutionality and that his rights were not violated or her rights were not violated. And that's what they should be doing anyway. That is their job. And so part of a defense counsel job and part in answering your question is to put everybody on notice that when you see me coming, I'm going to talk about all of it. It's all going to be on the record. So everybody knows what's going on.
And I want to say something here. Somebody in a very prominent position once said, judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. Chief Justice John Roberts said this during his confirmation hearing. Okay? I mention that because now, after the defense counsel says what they have to say and let it be known that they find this to be unfair, now it turns to this judge. And we're going to see what this judge does once you put forth that you feel that what's happening is unfair.
I love that statement.
What happens in many cases is, unfortunately, is some of these judges buy into or aid and abet this system in many cases.
Or they stay silent.
Or silent.
And like we said, no action is action.
Yeah. Action by omission, right?
Yes. And so, once again, you need to push your attorneys to figure out what is the I'm going to use the term sweet spot, because those who are accused, they know what they did and didn't do. And sometimes, as I tell clients that come in that may be guilty of some other act, but not guilty when they come to me, you know that. And sometimes you may have to do something that you didn't want to do. And this may not be the case that you test or not test.
And one of the things that we didn't even mention, which becomes more complicated, and we could talk about this maybe another day, is when you have a conditional plea. Some plea that where you're being asked, or your client is being asked to enter this plea, and then depending on a report or some investigation that is done about their background is when later on they'll get a promise as to a certain what disposition or sentence or outcome.
It's called dangling the carrot, and that is always a tough position for defense counsel
Tough.
because you have to evaluate whether or not you are putting your client in a more
Risky
in
situation.
a worse situation, right? A worse situation, or you're putting them in a situation that can advance them. And only your client truly knows, but your assessment of that client makes all the difference in the world. Because if you put them in a situation where they have to have probation or they have to wait a certain amount of time in order to get the ultimate resolution, then you may be putting them in a catch-22, and that is a problem.
So, what about some of the other areas when you talk about plea bargaining, but the case being over? Do some people just get caught up with that? Like, at least it's just over. So, if I just take this plea, I don't have to deal with this again.
Well, that's the problem. I mean, some clients are like, okay, I'll just take that if it means that for now I'm not
Going to
gonna be
jail.
confined, going
That's
to
right.
jail. If I'm gonna continue to be out in the street, fine. And not understanding that. Listen, if let's say the condition is that you stay clean, and your client is a drug addict, somebody who has a severe addiction. The chances of them being able to stay clean over the course of a year, say 6 months, a year, are you setting your client up for failure? Is that person setting themselves up for failure?
And don't even realize it. And this is where the whole criminal justice reform came in. So you have someone, and I'll take your scenario and go a little further, Dr. Grant. You said the case is over. So you have someone that couldn't make bail because of their social economics. They're in jail. They didn't do anything wrong. They've been in jail for 30 days. The DA's office come out and says, if you plead guilty, you jump in that turnstile, you get time served. That means you have served your 30 days already. You can go home right now. The pressures of not wanting to go back to whatever facility, whether it's a Rikers, whether it is you name the facility. There's a bunch of facilities, Spartford, whatever facility in Jersey. If you don't want to go back to that facility, despite your guilt and innocence, you may decide, you know what, this case is over. I'm done. I can go home. So I'll take that A misdemeanor or that B misdemeanor or that felony because I'm getting probation. And then it's not until you apply for a job or you try to vote or you do something, you realize that what you did before, either because you were ill-advised or you were hasty or you ignored the advice that was given to you, what you did before has now come back to hurt you. Even on a civil rights matter, you plead guilty to a case and it has nothing to do with the case that you've been falsely arrested for or excessively beaten. Your credibility now follows you, and that becomes a problem. Or your lack of credibility now follows you, and that
And
becomes a problem.
and just as we promised a little earlier, I just wanted to kind of quickly explain for the edification of the audience that this also takes place with respect to juveniles, okay? Because I just want to explain this. New York City has one of these unique situations, maybe not so unique, but it was a change. I used to practice criminal defense in Wisconsin, and what I mean by change is the district attorney's office not only handled adult cases, they also handled juvenile cases as well. Here in New York, it's different. Here, what happens is that a child, somebody considered a child, which now would raise the age, 17 under, you have a situation, well, depending on the crime, if it's not something violent where they try to keep the case in adult court, that case will more than likely go to what's called family court. And you would think, okay, family court, right? The prosecutor in family court is the corporation counsel, the New York City Corporation Counsel. okay, that corporation counsel office and most of the time, when you think of corporation counsel, you think about civil cases. They're the lawyer for the city. Here in this context, they're basically the prosecutor in these juvenile delinquency proceedings. And the same way in adult court, you have that level of plea bargaining and offers, conditional offers that look, listen, if you don't take this, then, this is only going to be available now before we go to hearing. That also exists there as well, unfortunately.
And that's a problem.
And that's a
major
problem.
problem. That's a major problem.
Yeah,
because you have corporation counsel, like you said, you have corporation counsel. You're on the civil side. You don't even have the expertise to really deal with the criminal side. And my experience has shown me that the judges that are on that side are used to dealing with family issues, family court, corporation counsel, usually dealing with petitions, whether someone has violated a petition, whether someone has done something in foster care, something that is not of
protective services.
Yeah, protective services, violated an order of protection, something that is not of the magnitude of carrying a weapon, participating in a robbery. And there needs to be some specialization when it comes down to that. And we need to recognize that. And if you have judges that are being pulled from a variety of areas to learn a particular section of law in what we call a nutshell, that is doing the system harm. And what do I mean by that? You have judges in New York State that they're in landlord-tenant court, and next thing you know, they're in family court. Next thing they're in family court, next thing you know, they're in landlord-tenant court. They're in landlord-tenant court in Manhattan, next thing you know, they're in family court in Staten Island. Then we could talk about another show on how they get from the Bronx to Staten Island, how they get from landlord-tenant court to family court in Staten Island. You probably rubbed the wrong shoulder and stepped on the wrong bunion, but this is what happens.
The bunion, Mr. Russell. Oh boy, it's the bunion.
Hey, look. When somebody step on your bunion, it hurts. And if you do something wrong in criminal court,
we used to call those corns, right?
No, exactly. Corns on top of your
well, I don't have either, so I don't know about
corns
this.
is on top of your feet. Bunion is on the
don't wear tight
shoes.
Feet.
You know what I mean?
You take care of the feet.
Legal versus cultural. Oh my goodness.
That's where the cultural comes in. And look, and if your mother stays around as long as mine, and as long as your parents stay around long, you're gonna see a bunion or two. You should be only so thankful. You know what I mean? But the point is that if you hit someone or do something, that people don't appreciate, then you can find yourself in a foreign land, foreign jurisdiction, foreign law, and then you're supposed to resolve the matter. And look, it's one thing to make a mistake when it comes down to someone's residency because you didn't practice in landlord and tenant court and now you're a judge there. It's another thing to decide someone's incarceration liberties when you don't practice in that area.
Now, I would love it if we could segue into something really nice regarding a particular jurist. I recently came across an article regarding this judge in Wisconsin, I believe in Dane County, who presides over a drug treatment court. And for those of you that may not be familiar, and I saw this happen, early in my practice, and we're talking the late 90s. You started seeing these specialized courts. Unfortunately,
you fronting. What do you mean early year practice, the late 90s? You mean early year practice, the early 70s, 60s? What are you trying to do?
Wow, man, how old you trying to make me, bro?
You lucky Dr. Grant. You lucky Dr. Grant don't have the sound effects. You early 90s. You mean early the 1952s? Okay, start with the 1952. Early in 1952. Tell me what.
What I'm about to say is that the first specialized courts that I started seeing, I'm not sure about you, Royce, I started seeing gun courts.
Yes.
I wasn't happy about them. I wasn't happy about them because what ended up happening is it came these like standardized pleas. Like everybody was supposed to get the same plea, no matter who they were or where they came from or, or their record, which was unfortunate. But then some of the progressives said, you want to have some specialized courts. Well, let's have a drug treatment court. Let's have a mental health court for folks who, so that we can put a judge up there who specializes in those cases and is familiar with that entire landscape. And so here, this judge presides over a drug court for, defendants with drug problems. And in this particular case, it's a beautiful article because it talks about how this judge looks at the individual and says, you know what, I'm not going to even treat this person like a defendant. I'm going to treat them like an individual and find out what it is that's important to them. And he found in this gentleman right here, photographed an individual who, despite his involvement in the criminal justice system, was a lover of chess. He used to play chess in the barbershop where he worked. And unfortunately, he used to also play chess when he was incarcerated. And so what does the judge do? He engages him about chess and say, you know what, let's play some chess, you and I. And it's a wonderful article because they play chess and the judge admits that, the gentleman beat him at chess, because he's that good.
The judge just had no choice. I mean,
Well, I said he admitted. He admitted. I said he admitted that he beat him.
He beat him straight up. But to your point, now you
should have let him win, right?
I mean, what I'm saying. But to your point, now you have a person, quote unquote, we use the accused or the defendant or Mr. X, who now has one more incentive to do right. Because now I don't want to go back in front of Judge Pichardo, Judge Grant, Judge Russell, and have to really face that judge when I fell down or intentionally did something wrong, especially after we shared that moment. And so those are the out of court type of incentives that need to be there. And now the judge is not looked at the villain. The judge is looked at as an individual that cares. And that brings me to a point where, sometimes you engage with clients' parents and clients' loved ones. And I'm going to draw this line. They think it's all right to whip you because they mad at their sons or their daughters or whatever situation. And that's not all right. It's not all right for you to take out your frustrations and try to lump me or Ed or anybody else. You're the part of the system and my son shouldn't, or my daughter, and that's messed up. Oh, wait a minute. You hired us to protect your loved one. And I can understand that you're frustrated, but you need to draw the line and you need to say, Mr. Russell or Mr. Pichardo or Mrs. Grant, this is not directed at you. This is my frustration. Often that gets lost in the cultural part of what we do. And it comes out as if you're part of the problem. And anybody who knows me, there's no whiteout in my book. We're going to correct it right then and there. We're going to correct it right then and there. That we will have none of that.
Well, I think that's a greater conversation around the blame, the frustration. It's so much that goes into it. But I love that, Mr. Pichardo, you brought this article to our attention because it shows there's hope of how we can do criminal justice differently and how we really can look at ways to treat people with a level of humanity, even if they made a bad decision, even if they intentionally did something, that everyone can learn from it and be rehabilitated back into community properly. But that's a whole nother show and a whole nother process. But hope springs eternal, right, Ed?
Yeah, absolutely. Hope springs eternal, for sure.
Yeah, well, look how far we are from spring.
All right, great.
I don't want to tell you how far we from
bridge.
Eternal, right?
All right, great.
There we go. All right.
Well, this was a very good conversation to really understand plea bargaining, where the legal meets the cultural. This is why we talk about these issues, because so much of it is happening and we really don't know what recourse. And we talk to people, and you know what I say, the sidewalk attorneys, you don't need that. We have two legal experts here that you can call, and the laws are different in certain states, but at least start with reaching out to law office of edwardpichardo.com or roycerussellesquire.com to set up a consultation if you really need some more insight, particularly with the plea bargaining. And there's a lot of legal issues that are heightened now because of this COVID world that we're living in with multiple layers. So make sure you just at least keep their information handy so that if you are in a situation, or you know someone who is, you don't have to think about who to call. You have two experts right here who can answer.
Absolutely, absolutely. Door is always open.
My door's cracked.
It
Of
does
course, he
crack.
would say that.
My
Well,
door's
final
You might
thoughts,
cracked.
get it, you
gentlemen.
might not.
You know. Final
Well, let's.
thoughts. Final thoughts. My door is cracked, and you can open it gently, and we can have that conversation. Royce
Oh
Russell
my goodness.
ESQ.com, R Square ESQ.com. There you go.
Well, my
Thank
final
you for your
words
crack door.
is Royce is bluffing. This is one of the nicest guys in the world. He talks to everybody. I mean, you call him, he's going to give you excellent advice, or find somebody that he feels will be able to give you that competent advice that he might not be an expert in. Softy. Don't worry about him. You call him up. He's going to take care of you.
Yeah,
His doors aren't going to be
you lucky I
cracked.
don't have your
Go ahead.
number readily available. You lucky I don't have your number readily available. I was about to give it out. 718, you know what I mean?
Oh my
There we go.
goodness. Well, with that, ladies and gentlemen, we thank you for tuning in to Speaking Legally, where the legal meets the culture, with your two legal experts, Edward Pichado Esquire and Royce Russell Esquire. I'm Dr. Grant. It's a pleasure having you join in the show. We're going to comment on all that you've been sharing. Thank you for being here, and we'll be back next week, same time, same place. Bye bye.